Right.
Okay, there it's mounting, yeah.
Yeah, welcome everyone. Everyone should be starting to. Hi, Danny speaking. I've just opened it up to allow everyone in now. No, yeah. Perfect. Try again, just check. Everyone, just last minute fixing ups with the presentation. I'm sending out the notes to everyone at the moment, and then we're going to start shortly.
We should start in a minute. That's at 10 past. Is that okay?
Fine. Yeah.
Okay, so we're going to start. I think others that join will let them catch up. Welcome to the CPD course on financial immigration and related matters. We welcome our panelists and presenters. That's Anthony Chait, Mike Kirsten, Nuno Moscolini, and Robert Verkale, all from Ziridium. I'm not going to say anything about financial immigration, of which I absolutely know nothing. And if I'm going to leave it in the hands of our capable presenters, who are experts in their field. There are 4 people that will each be presenting. And just on housekeeping matters, we will be having a break approximately on each house. There will be 2 breaks. Comfort break, it won't be for more than a few minutes. And the second thing is, please, we'll mute you. If you want to ask questions, please put your questions into the chat area and we'll take them at the end, the the presenters will answer any questions that you may have. And yes, so Anthony and your team, the floor is yours.
Good day, everyone. Thank you for joining us. It is evening where I'm presenting to you from Melbourne, Australia, down under. And my team are in Johannesburg, whom Stan have already introduced. I'll just mention to you that they're all part of our team. They're all experts in what we do. And just from an individual point of view, Mike Kirsten was a former head of Emigration at the South African Reserve Bank. On his retirement, he joined Ziridium, and he's been in a consulting capacity for a number of years. We're very grateful to have him on board. Then Robert Verkale is also part of our team and assists many people with the aspect of immigration. Robert's going to speak specifically on the tax residence rules insofar as they come into the presentation. Perhaps what I'll do is just put up the course outline. And then Nuno Muscolino is also, he's in Cape Town, South Africa, and he joins us too. He's also part of our team. So as was advertised, the main areas that we're going to cover during the course of this webinar is firstly financial immigration, quite a hot topic, very topical at this point in time. And in fact, whilst people would have preferred that we presented this after the end of the month when they had all their tax issues, provisional tax and so on out of the way, you will see during the course of this presentation that in fact we're in the final throes of financial immigration, and therefore it's an opportune time to talk to you on this. Then the exit tax, the expat tax, tax residences, I say, that Robert will deal with, and then some of the issues that we want to draw your attention to around this subject, but that relate to your February payroll, also something that is extremely topical at the moment. And this course, it follows soon after the one presented by our colleague and friend Hugo van Zyl, who covered, I think, a lot of these areas fairly extensively. Those of you who might have attended previously would have heard Hugo on this subject. Hugo is actually currently in Dubai as part of his work. And the reason why, together with CPD courses... So do you have problems with my audio, Stan? Okay.
No problems. I think some people are not muted. Maybe Danny.
Okay.
You should mute
Can
everyone.
you mute everyone, Danny? So yeah. Yes. So we decided to mount this seminar as a follow-on to the previous one, with the main emphasis on some of the more practical considerations. Hugo would have dealt in great detail with the actual law, and we've focused more on some of the practical issues. And then, of course, as Stan said, we'll deal with some questions. We had, prior to us coming on air, a number of questions which we've incorporated into some of the slides. We'll deal with those. And then, of course, you're more than welcome. There's ample time at the end. And not only myself, but our panel will gladly take those questions and try and resolve them for you. Also, as part of the pack being circulated are our contact details, mainly in terms of email addresses. So if we don't cover everything and you have questions after the end of this webinar, you are more than welcome on an individual basis to put them to us at the email addresses that we provided, and we'll do our best to respond to them individually. I should just say that you'll see as the presentation unfolds that some of the aspects are in fact quite fluid, and there's some documentation and announcements that are due fairly imminently from the Reserve Bank in terms of this financial immigration process. We tried to include in this presentation these developments as they happened up until a short while ago, but there is another release due out tomorrow, and we'll touch on it as we get into it. So the background to, first of all, the concept of immigration. It has been around for some time, and over the last 10 years, there's been particular developments, liberalizations, modernizations in our exchange control system, and as part of that, and I think that was the main reason, I suspect, and it'll become apparent afterwards that there may be other reasons, but as part of that modernization of our exchange control system, Minister Tito Mboweni, in his budget of February 2020, announced that the concept of financial immigration would be abolished. And a timeline was set for it. So there was a year to phase it out, so to speak, or it would be phased out after a year. And that date is fairly imminent, as we know, as in fact the 28th of February 2021, which is just 10 short days away. So that's the background to the situation. Now, from an exchange control point of view, and when we talk about financial immigration, a resident is defined differently depending on what aspect you're looking at it. So from a tax point of view, you are tax resident, as most people are tax resident in South Africa, until you cease to be tax resident, and that will be discussed during the course of the presentation. And then, of course, you are exchange control resident, and being a resident for exchange control doesn't or isn't in any way informed by the tax definition. That has a definition all of its own. And if you live in South Africa, even though you may be a citizen of another country, but perhaps have permanent residence in South Africa, because you'll see there was a question right at the end that we'll deal with in terms of someone who's a citizen of another country, then you are regarded as being a resident for exchange control purposes under the current regime. And in fact, even if you or your client leaves or has left South Africa, it's not mandatory to financially immigrate. A lot of people have and clogged the system, but many people, either because they don't have assets, they just get up and go, so to speak. They leave. And they are still resident for exchange control purposes. And their status, in the eyes of the Reserve Bank, is one of a South African resident temporarily abroad. Okay, so you have the almost anomalous situation that someone could be out of the country for 15 years continuously, have left, perhaps never returned other than for short or brief visits to family. If that person has not embarked on the process of financial immigration, then they would be what we call a SATA, South African resident temporarily abroad. So there you see the distinction from two sort of different angles, completely different angles, between someone who's tax resident and someone who is resident from an exchange control point of view. Now, the processing of immigrations, I think most of us are pretty aware by now, is an authority or something that is being delegated to some extent by the Reserve Bank to the authorized dealers, not in terms of the approval process, but in terms of the acceptance of applications to financially immigrate. So one can't go to the Reserve Bank building armed with one's MP336 and say, I'd like to immigrate, please. You'll be quite simply turned away. You need to approach one of the authorized dealers. The authorized dealers typically are the major banks in South Africa. They're licensed by the Reserve Bank, and they're the ones who would, on the behalf of any would-be immigrant, accept the application for immigration. And that application, and we're going to spend quite a bit of time in a short while looking at that document. It's called the MP336, and it's the key or pivotal document in this whole financial immigration process. For those of you who are professionals who assist clients with immigration, then, and this seems to have been a relatively new requirement of the Reserve Bank, possibly because of or rather a requirement of the authorized dealers, is if you're approaching an authorized dealer on behalf of your client, then you would need beforehand for your client to provide you with a power of attorney, just authorizing the bank in those circumstances to deal with you. And it would need to then be signed by your client. There's a concept, it's less relevant now, but I'll deal with it because it's an interesting one, and I personally hate the word. And that's the concept of a failed immigration. And there is within the system a principle that if you return to South Africa, and it was probably more relevant in days gone by, where you were allowed things like a settling in allowance, to take funds within a certain allowance outside, or to export those funds from South Africa as a settling in allowance. And if within a period of 5 years you decided to return for whatever reason, then there was a requirement to almost, if it was within that 5-year period, to return the funds that you were so allowed to export. And then just the final point, and that is this aspect of the tie between citizenship and immigration. And many people have discussed this with me. It is, as I mentioned, there's this emotional umbilical cord. Many people love South Africa. They regard South Africa as a paradise. South Africa and Africa is in their veins. And they say, well, if I was to financially emigrate, would I lose my citizenship? Is that a renunciation of citizenship? Can they take my citizenship away because I've financially immigrated? And that is completely not the case. Citizenship is governed by the laws administered by the Department of Home Affairs under their applicable minister, and citizenship has nothing to do with immigrating. You can immigrate and still be a South African citizen. You can acquire the citizenship of another country and still retain your South African citizenship. Two rules really apply to that. You just need to keep your South African passport current at all times. And when you visit, in fact, when you arrive at an international airport in South Africa, and when you depart, you need to do so using your South African passport, irrespective of the passport that you may have left your country of where you left from. So let's just look now at the MP336 as a form and take you through from a practical point of view, some of the aspects in completing such a form. It's called, and this has been its name for as long as I can recall, an MP 336B. And you might say, well, what happened to the MP 336A? And what is the fundamental attribute of an MP 336 in terms of its predecessor form, which, as I say, was called the MP 336A? And the difference is in the second bullet point on the slide, and that is that the MP 336A, and this a lot of people don't understand, only requires you to disclose your South African assets. So if you have, through legal means, been making use of your allowances and exporting funds from South Africa, perhaps you have a foreign trust or whatever, then you're not meant to disclose or reflect those assets on the MP 336B form. So a very important aspect, it's for South African assets only. And you'll see there's a point, and we'll deal with it later on in the slide, that where you need to apply for tax clearance, very often in the first instance, and the MP 336 with those South African assets, in the way in which SARS approve and grant you tax clearance, is they do a comparison or a reconciliation, if you like, between the assets per your MP 336 and those that you would be required to reflect on your tax clearance application that you send to SARS. So all the more reason why it's just your local assets, and they should be capable of being reconciled with the information that you give to SARS. The next point, and this is an historical one relating to the MP 336B, and it really is a unitary form for an entire family unit that is emigrating. In perhaps a chauvinistic society that we were, more so in earlier years, the applicant is presumed to be the male, and then details are required of his spouse, and then the children. So so those are the three parties to a single MP 336 that is generally completed. Now, the question is who is excluded? So sometimes people who have left South Africa a number of years ago, and perhaps they left as a young couple and only started their family in their new country of residence, and their children, say, are all born outside of South Africa. So in those circumstances, you would simply not reflect the children. So it's only South African born children, and the form requires their identity numbers. And in those circumstances, you wouldn't have the entire family, just those who were South African residents or who are South African born. Another interesting aspect is many years ago when I started in this field, there was an expectation that it being a family unit, you had to describe the husband and the wife, or both spouses. Nowadays, and it's not uncommon, and in fact, indeed, quite acceptable, just for only one of the spouses to emigrate. There may be no need or reason for the other spouse, so to speak, to immigrate. And the Reserve Bank are quite happy with that. So that's the background in terms of the family unit, but you can do it for a spouse individually. I think the form does ask if there's a reason why the so-called other spouse is not emigrating. Now, there is one of the important other bits of information at the beginning of the form is what is called the intended date of departure. And this is relevant to what's going on right now, and I'll refer to that. So ordinarily, you apply to emigrate financially prior to leaving South Africa, and you insert what is your intended date of departure. We normally tell clients that they should at least hold a valid travel reservation on an airline or perhaps a ship, and the date of that travel arrangement would be inserted as the date of departure. Now, as we are nearing close to the end of financial immigration, and as I mentioned, it's just 10 days ago, and people wish, and hopefully it'll become apparent during the course of this presentation, why there is in fact a rush and why there's a desire or a need to immigrate now and not wait till after March. The authorized dealers will have a difficulty, and their expectation, if you're yet to leave, is that you must have a date of departure probably in about March or April, I think, at the very latest. So if your departure is long dated, if you're thinking of only leaving in December of 2021, you will find, based on our experience and what the authorized dealers have informed us, that they will decline to accept that MP336, that application to financially immigrate, and they will in fact rather recommend or suggest to you that you apply or follow the new regime that will come into force post 1 March 2021. So that's quite important for people who are in the process of immigrating and who are completing this form on that basis. Then what about all the other people? And this currently, in our experience, is making up the bulk of the people who are immigrating now in terms of applying for the MP336, is they are, as I mentioned, South African residents temporarily abroad. They may have been abroad for considerable periods already, and they're now seeking to place that immigration on record with the South African Reserve Bank. Now, when it comes to a date of departure, well, that's not really relevant, because the fact is they have departed already. And I referred to a concept of retrodating or backdating. Backdating normally offends a lot of people because it suggests that the document is being tampered with. So retrodating is really just using a date retrospectively where that relocation or migration took place. So, and it may be any time in the past. The sort of things one would need to watch out for if you are, let's call it backdating, because I think everyone knows our intentions are completely honorable, and that is practically what it is. If you wish to backdate, or the appropriate dates to which to backdate an immigration would be the date of the granting of your visa, citizenship in the new country. Those are all acceptable dates, dates acceptable to the Reserve Bank in terms of the retrospective nature of the process. One just needs to bear in mind that that could be problematical because you'll see I make mention of the SDA on the slide. That's the single discretionary allowance. There's a presumption that you take your single discretionary allowance, that's the 1 million that I'm referring to, by the way, as a resident. So if you have been sending out your 1 million, and the Reserve Bank keeps a record of this through the BOP forms that are completed, then you will they will jump on you and say, look, we cannot backdate your application because we see from our records that you've used your single discretionary allowance in the previous years. It may even have been a travel allowance because the single discretionary allowance came in October 2010. So perhaps if you left in 2005, but took your travel allowances in those years, and there's a record of it, then you'll be precluded from backdating. But that's not the end of the world, because in most situations like that, we would just make an application and we would just say from the current date. So we would ask the Reserve Bank through the authorized dealer to treat your effective date of immigration as the current date of the application. Now, the next very important aspect that you need almost as a prerequisite to complete the MP336 and therefore to financially immigrate is that you must be able to demonstrate with appropriate evidence that, first of all, in which country are you immigrating to, and you need to show that you have a right of residence in that country, and that would typically be if you're newly going into that country, you would be issued with some or other visa that would give you landing rights or a right to stay in that country. And some instances, that visa application is quite a lengthy process. For example, in Australia, certain of the visas take many months to apply for before they're granted. That doesn't preclude you from immigrating yet or filing for immigration. What we would normally do in that situation is, if you've used the services of an accredited migration agent or immigration lawyer, for example, if it's to the US, where it's sometimes difficult if you don't have a green card or whatever. And upon that lawyer or agent, as the case may be, writing a letter to say that there is in fact an application for a certain visa, which is likely to be granted. In other words, that person meets all the requirements of the visa, and it's just being processed by the foreign government. That is quite acceptable. And then you state on the MP336, in earlier days it was quite a crucial amount. It's less so now, again in the last 10 years, because of the generous, I say generous because it's an annual allowance. Before 2010 it was actually a lifetime allowance. And that's the 10 million. You can apply for more. And then there's also the matter of the SDA. And I seem to recall in the instance of the travel allowance, and I might ask it right at the end, Mike, to comment on this, but used to get as a once-off an additional travel allowance because you were leaving. And in fact, the MP336 form to this day that's in use still makes provision of it. So I wonder if you could have a double whammy, Mike, not for answering now, but later, of if you've taken your million in January and you're leaving in February or March, could you get an extra 1 million or not? Your views on that would be interesting. Then another part and parcel, in fact, of the immigration process, and this is where you go knocking on SARS's door, and that is to obtain a tax clearance and that is a very specific, it's done online today. In the olden days, it used to be called an IT21A. Nowadays, it's all online, as is the normal foreign investment allowance. I think SARS have come a long way in terms of their systems and so on. And you would apply online for a tax clearance, which is a requirement, and we'll talk about that in a moment, and a requirement before the Reserve Bank will approve your immigration. You need a valid tax clearance or an an exemption from furnishing tax clearance. Now, you would be exempt from furnishing a tax clearance because you may have been out the country for many, many years. You're no longer a member of that elite club of SARS. They've dropped you off the mailing list. You don't hear from them. You're probably quite happy about that. And how do you now start getting tax clearance? So the rule is that if you have no other assets in South Africa other than an insurance policy, because you'll see we're going to talk about why people are and why there is this rush to emigrate. It's people who have RAs or pension funds and they're under the age of 55 and they wish to encash those and take export the funds out of South Africa. So you would be eligible for exemption from tax clearance if you had no assets in South Africa other than an insurance policy. There's a bit of a difficulty in terms of claiming that exemption. I was discussing it with my colleagues a little earlier in preparation for this, and that is because I find this quite common, that some people have no assets. They might have their RA, but they have a bank account, and there might just be a nominal amount in that account. They've kept that account open. Perhaps they use it when they go for holidays or so on. And it would seem, as ridiculous as that may sound, that having a bank account might still push you into the route of needing a tax clearance. So what we sometimes recommend, if that is an impediment, is to just simply close that bank account, give it away, or perhaps we'll happily charge you fees up to the amount that's in your bank account, and that would certainly solve that problem. Okay, when the MP336 requires details of the various assets under certain categories. I've shown some of those categories on this particular slide. And we recommend, just for ease of reconciliation with the actual tax clearance, is that if there are two spouses, because bear in mind that if there's a family unit and two spouses and they're both immigrating, and today and ever since 1992, South Africa has separate taxation of spouses. It was ridiculous as it was, but I was in practice in 1992 or prior, where, and again, that just showed how chauvinistic the country was. There was one tax entity, and that was the husband. The married woman, as she was then known, was not capable of registering as a taxpayer. Her income was added to that of her husband and taxed at his marginal rate, and they comprised a tax unit. But happily, since 1992, when separate taxation of spouses came in, each spouse is entitled to register with SARS separately, and therefore, upon registration, upon immigration, each spouse would require a tax clearance. And just to make it easy for SARS, because they're then going to get, remember, there's one form, one MP336, two tax clearances. So we find it's a nicety just to simply show the assets separately under each category, one for the husband and one for the wife, or for each spouse, so to speak. And then just some of the comments regarding those categories. And this is another interesting aspect that's going to change and maybe for the better. If there are fixed properties, then the title deeds to that property needs to be lodged, and the proper wording is held to the order of the South African Reserve Bank by the authorized dealer. So, it goes back to the days when assets were blocked, as it was called, because you had blocked assets, you had a blocked account, and you had a remittable account. And the form to this day still asks you to surrender the title deeds of a property into the authorized dealer for safe custody until such time as, if you wanted to dispose of the property, you would then have to go to the process of approaching the non-resident center of the bank, who's the authorized dealer, to say, I've sold my property. And in that instance, you've probably long since gone, and someone else would have to do it on your behalf, perhaps your auditor, and retrieve those so that they can be presented in order to register the transfer into the name of the buyer at the deeds office. What we don't know after March, when this concept falls away, is whether there will in fact be a requirement to lodge these documents. What a number of people do in practice, because you don't always have title deeds, as you would be aware. I mean, if that property is bonded, then the bondholder, the financial institution, would hold as a part of the security in that institution's possession the title deeds. I know of a number of people who purposely they may have paid off the bond. They might leave R1 as the balance or paid off completely, but don't worry about cancelling the bond, and then forever and a day the bondholder, even though you don't owe them anything, provides you with a free safe custody service for your title deeds. So that's what one encountered in the past. Listed or unlisted investments that you hold at the time that you're emigrating, a lot of people try and sell them. Seems, and I'm not licensed to give you investment advice, but it seems that the JSE is at good levels. But if you decide not to sell them, then upon the financial immigration process, those shares get endorsed non-resident. Now, prior to the year 2000, which is when I think South Africa introduced the straight system, and there was a process whereby every counter on the Johannesburg Stock Exchange was dematerialized, and they did away with paper-based share certificates for listed companies, that is. Then, and that was replaced with a CSDP system, a form of repository, which is administered by the organization known as Straight. And but nonetheless, whether it was paper-based or electronic, that has to be endorsed non-resident. It has some number of advantages to it, two that I can think of immediately. Number one, upon the selling or sale of those shares, the proceeds would be remittable offshore if they were so endorsed. During the period that they're held, the dividends received on those shares can be paid into a remittable account and remitted offshore at will. You don't need to do it as part of your 10 million allowance, for example. Insurance policies, you need to log all the full details, and debtors, and we find that normally refers to loan accounts. Those are listed, and invariably as part of the package, you'd need to get those, the person who's indebted to the immigrant to sign a loan certificate just for confirmation. I must just say that the MP336, is apparent in just the short while that this presentation has been on the go is hugely documentation intensive. And if you thought it was onerous, we're still in the middle of it, because the next aspect that needs to be demonstrated, this puts a lot of people off, is you need to tell the Reserve Bank any interests in trusts that the would-be emigrant has. And this would be trusts where they are a beneficiary. And whether it's a discretionary trust or a vesting trust, the requirement to advise the Reserve Bank of that interest is necessary. Now, like the overall comment that I made earlier on, it's only South African trusts that you have to note. So if you have a foreign trust that's legal, or maybe you took amnesty way back in 2003, in which case it's what we call an amnestized trust. Foreign trusts or foundations do not require to be reflected on the MP336 or your interest in them. I've mentioned beneficiaries, or beneficiaries need to reflect it. And here's an interesting one that not many people are aware of, and that is when you look at a trust, insofar as it affects an immigrant, we need to decide, is it what is called an own assets trust or a third-party trust? Now, it's not as complicated as it sounds. An own assets trust is simply a trust that you yourself create. You put those assets into the trust, perhaps for reasons of asset protection, protection of minors, or for whatever other good reason. And those are yours, and you can award the assets to yourself and externalize them without any problem. So that's why it's important to establish whether it's an own asset or a third-party trust. A third-party trust is a trust formed by someone else. So you might be the child of a mother or father or grandparent who at a point in their time, and they were advised to do so for state duty and other good reasons, formed a trust and made you, as their child or grandchild, as the case may be, a beneficiary of that trust. That is what we call a third-party trust. And you would still, much in the same way as an own asset trust, you would need to reflect that on the MP336. So for both of those, in other words, in order for the Reserve Bank to establish whether it's an own assets or a third-party trust, and what the distinction is, or where there could be an impediment, you will see shortly. But we ask the question, who is the real funder? And very often that's done by quite a laborious analysis of the financial statements of the trust in prior years, who funded it initially, who put in the seed money into that trust. And let's not confuse that with the donor in the trust, because the donor and the funder can quite typically be two separate people. The donor is very often, and again, this is the more old-fashioned way of forming trust, but they were done, many of them are still around, done. I saw one recently that was done almost 40 years ago, and we're now looking at the immigration of the individuals, beneficiaries. They're probably third generation. And the donor would have been that original grandfather who perhaps contributed a donation of maybe 500 Rand, 1,000 Rand. And the recordal of the trust, the opening paragraph would have been, I, John Peter Smith, out of the natural love and affection of my dear wife and children, hereby donate the sum of 1,000 Rand in trust. And then perhaps other people used that trust, either that person himself, in which case the donor and the funder would be the same, or someone else used the trust, funded it, and that's why we need to distinguish between the two. Now, an important question in relation to some of those older trusts is that funder still alive? And it makes a huge difference. That gives rise to what we call Regulation 4.2 issues, which means quite simply that if the funder is still alive and some of the beneficiaries emigrate, then they cannot export those capital awards until the death of the funder. So they can be paid out by the trust. They would get held in this instance, the blocked account by the authorized dealer, but the Reserve Bank will not permit you to remit those funds abroad until the funder dies. Income of the trust may be remitted, but not the capital. And then any capital awards within 3 years of emigrating. So if you receive, and there's a question, a part of the declaration section, which we'll come to in a moment, where they ask, did you receive any capital awards within 3 years of emigrating? And the reason for it is perhaps not that obvious, but I'll explain it to you. And that is quite simply, if one person seeks to export capital and those funds are in a trust, you can't simply award it to the person emigrating so that person can take it out of the country. There is that 3-year rule that one has to be mindful of. Getting to the end of this MP336 form is the value of items to be exported. Again, only if you are really going now and you're taking a household shipment, and invariably not too much attention is paid on the values. I think there's they ask for an insured value as well. And very often, if you're using shippers, they will assist you with the completion of what is an NEP form, and which is largely from a customs point of view, and you would attribute a value if you are taking goods, household goods at the time that you are emigrating. So then at the end of the form, your signature is required, and there are 3 declarations or questions that you're required to provide answers to or disclose. Have you received any gifts in the past 3 years of 100,000 or more, or any capital awards from a trust in the past 3 years? And the purpose of those 2 declarations is the same, and that is to prevent people, and it's more applicable prior to October 2010, as I say, before the relaxation of exchange control, but it's still on the form today. And so if we just understand why that declaration is required, in the earlier days when it wasn't that easy for people to take money out the country by means of the 10 million, prior to that it was 4 million, and it was a lifetime allowance. So to obviate people emigrating and being given the money to export by someone else or where it's in a trust, this declaration needed to be made. And if the declaration was truthfully answered, there could be an issue with such amounts. And as I mentioned, much like Regulation 4.2, it could be blocked. And then there's a requirement just to show any previous capital transfers. In any event, the Reserve Bank would have most of those because every time you send money out, be it on your STA or on your FIA, you fill out a BOP form, and that gets reported to the Reserve Bank, stored in the cross-border department of the Financial Surveillance Department, and that's how they keep a record of it. So if you were to try and be too clever and go to bank A, take your $1 million, a month later go to bank B, ask for another $1 million, the Reserve Bank will pick that up very, very quickly, and you'll be in trouble. Now, the signatures, the last aspects of the MP336, and that is obviously the applicant and the spouse. I've put in a point there about wet inked or scanned, very, very topical at the moment, because we are, as I said, 10 days away from the end of the month, and the would-be immigrant who is doing so purely for purposes of, say, an insurance policy, and we'll see what rules affect that shortly. That person, I am dealing with someone at the moment who's been in Hong Kong for 15 years. They may be elsewhere. A lot of the flights in and out of South Africa have been curtailed. It would take probably a minimum of 10 days for that person to sign his MP336 in wet ink, which is what we call wet ink, and then entrust it into the services of a FedEx or DHL, and send it to South Africa for processing. So we've asked, and again, I might ask Mike during question time, or any of the other guys, we do have some information to you, and in fact an announcement is expected tomorrow as to whether, which would be far more expedient, you could simply sign that document in Hong Kong, as I mentioned, and scan it and send it to where it needs to be. Final point, being a sort of best practice that I will share with you over many, many years. And you'll see that whilst the form is fairly detailed, been through the various questions that are asked, there's not much space to provide details, and also usually there's a background. And so I always think it's good form if you're a practitioner and you're assisting someone emigrating, or even if you're emigrating yourself, it can be done on a DIY basis, to do a covering letter and just explain to the authorized dealer exactly what is going on, particularly if one spouse is emigrating and the other isn't, or that is generally the place to set out an explanation, because it isn't provided for elsewhere in the form, so that the Reserve Bank then, or rather in the first instance, the authorized dealer who's going to check your application and your MP336 can be fully informed of everything. Right, I'm just going to take just a sip of water. How are the questions coming in? Right, now we get to the reason for the changes, and in fact, what is promoting this rush? I mean, why are we presenting a whole webinar on financial immigration, on the practical implications, on a form that within 2 weeks will completely be in disuse? You know, what is so important, so relevant about financial immigration that we are spending so much time in our busy days or nights looking at this? And it's all to do with a change in the tax law, which followed on the heels of Minister Tito Mbowene's announcement that I referred to right at the outset in the February 2020 budget, when he said the concept of immigration, or financial immigration as it's become known, is being abolished. So SARS, because it's in their legislation, in the definition of pension preservation funds, provident preservation funds, and retirement annuities, in those definitions, there is a clause which says that anyone under the age of 55 may encash their RA, as the case may be, and in fact take or remove the full funds from the Republic, in other words, without the normal rules that affects people once they retire, of commuting a third, buying an annuity, and the modern day product, which is the living annuity. And it's interesting, dealing with a client who did emigrate, a lady of 94, been out of the country for 34 years. In fact, there's a FICA issue because she doesn't have a green barcoded ID. And the particular authorized dealer will not, and I think they're incorrect, and that's where I've got involved, will not FICA her account, but her annuity at 35 years ago was long before the days of the living annuity, and it's one of those conventional or gewone retirement annuities, and she's having a problem all of a sudden in getting that sent to her, a lady of 94, I ask you. So these are the three types of funds where which has caused this flurry to immigrate. There are some other reasons. Perhaps I'll just touch on them. It's probably because I'm not sure I cover them in a slide elsewhere. I've had a number of people approach me in the last couple of weeks saying, look, I want to emigrate. Should I emigrate? And I would say, sir or madam, I'd love to take some money off you and charge you a fee and emigrate you, but I don't think it's really necessary. No, I want to immigrate. And I say, well, why? And they say, no, please, I want to immigrate. I just want to close that pigeonhole. I've left South Africa, and please, I want to process my immigration. So there are people who, for the reasons such as the one I've just mentioned, and that particular person is not alone in their thoughts, who are not or don't have one of these three types of retirement funds, but nonetheless feel that they wish to at least financially immigrate. There's perhaps another reason, and I think again it's appropriate now. Stan, I see we're sort of an hour in, and I'm happy to continue, but we'll take a break shortly if someone wants to pop to the fridge or put on the kettle and make themselves a quick cup of tea or coffee.
No, that's fine. Do you want to do it now, or do you want to wait?
All right, yes.
Come back.
The problem is I'll probably forget where I am and what I wanted to say, but I'll remind myself. So, yes, Mr. Chairman, would this be a good place for us, as one would say, if one was addressing the court? One would say, my Lord, would this be a good time to adjourn?
The judgment is that we come back at 2:15.
Okay, good.
Anthony, can you hear me?
Yes, Mike.
Okay, no, I'm just testing. Okay, I just thought I unmute. Okay, no, it's going well, I think.
Okay, good. You may want to mute, and we can chat. Call on you later, Mike.
Yeah. Okay.
Okay, so we're back. Nobody, so the same number of people are still online, so nobody immigrated in the interim. So, Anthony, please continue.
Yes, thank you, Stan. And in fact, yes, to the number of participants, as I say, I've done a few of these, and there's nothing more disheartening to the presenter when you start watching the number of participants steadily decline. You're either offending people, they don't understand your jokes, or you've gone on way too long. So for those of you who are out there who are listening, thank you for your attention, and hopefully this is worthwhile, and we'd appreciate your feedback. So just to remind us where we were talking about the retirement funds and what has in fact occasioned the tax amendment, which I believe was recently promulgated. I believe the date was the 20th of January 2021. But this was all proposed and in the Taxation Laws Amendment Bill during the course of last year, and has now been put into law. Now, a person who is emigrated, in terms of the definition, as I mentioned in the definition of those three different retirement funds that I had up on the previous slide, is someone who is or was resident who emigrated from the Republic, and that immigration recognized by the Reserve Bank for applications received on or before 2021. And he has an interesting bit that I actually didn't notice before, and it said, and approved by the Reserve Bank or an authorized dealer in foreign exchange for delivery of currency on or before 28th of February 2022. So it seems that the Reserve Bank, and maybe they needed in terms of this huge volume of applications. We heard from one of the authorized dealers just a short while ago today that they're absolutely inundated, as you can well imagine. And so they will get them off their desks and onto the desks of the South African Reserve Bank, and then at least that's the situation prior to the 28th of February. So the way in which the law has changed after that date, after 1 March, is the following. And this is perhaps, probably, and almost singularly the real reason for the rush and what has prompted us to hold or given the topicality of this presentation at this point in time. And that is a person who is not a resident, and now immigration, you'll see, is no longer mentioned in the law simply because immigration doesn't exist as a concept. Not a reason for an uninterrupted period of 3 years or longer on or after 1 March 2021. So, and there are difficulties we are going to deal, and we'll go through them fairly quickly, in the exit tax and ceasing to be tax resident and so on. So the paraphrase of this particular legal provision is that in order to take your RA or one of those other 2 retirement funds that was previously mentioned, after 1 March, obviously there's still the requirement that you need to be in the fountain of your youth, under 55, and you will have to prove to SARS, because they're the ones who are going to administer this, that you've been non-resident for tax purposes for an uninterrupted period of 3 years or longer. So it's interesting, uninterrupted period. Obviously, you can come as everyone does for a visit, a holiday, see family, but in terms of your residency, you must be continuously a non-resident for tax purposes for an uninterrupted period of 3 years or longer. So why does that present a problem to people? Why not say, and in fact, let me save these exorbitant fees to have someone assist me with my immigration. Why don't I just wait until after the 1st of March? And this would apply and may apply to many people who have long since been out of the country and clearly wouldn't be or would have already satisfied on the 1st of March. So on the 2nd of March, they could have their representative rush into SARS and say, here you are, my client left South Africa in 2005. That's a period way in excess of 3 years, and therefore my client wishes to encash their retirement annuity. Now, ordinarily people would be quite happy to do that. I think when you compare the 2 organizations that are involved here, on the one hand, the South African Reserve Bank, on the other hand, the South African Revenue Service, they, whilst they're 2 sister organizations, they both report into the same minister, Minister Tito. The Reserve Bank is perhaps a little more independent, and that's under Governor Lesetja Kganyago, who does a brilliant job. And on the other hand, his colleague, Commissioner Edward Kieswetter, who is in charge of SARS. And why are they 2 different organizations? They have different functionality, largely, one would expect that. And there's a difference from a cultural point of view as well, and this is the all-important aspect. The Reserve Bank is driven, informed by policy, rules and regulations. I'm talking about insofar as exchange control, because there are other people who make sure that the banknotes with Nelson Mandela on the front are in circulation and don't get too tatty and so on. I mean, that's one of the many functions of the Reserve Bank, regulating regulating monetary policy and so on. But just in terms of financial surveillance, as the Exchange Control Department is now called, many years ago, the name was changed, they operate and function differently under a different constitution, under a different act, the South African Reserve Bank Act. Yet their colleagues at the South African Revenue Service, the culture is completely different. They are process-driven, and there is a concern. Well, I think Commissioner Edward Kieswetter is doing a great job since he took up that position. I don't want to talk of the state capture years and the previous commissioner. That just wouldn't be appropriate. But under the control of Edward Kieswetter, South African Revenue Service is functioning much better than it was previously. But yet, by his own acknowledgement, they lack the state funding that SARS, as South Africa's supreme revenue collecting organ, requires. And just to give an example, years ago, and I've been a tax practitioner for more years than I care to remember, SARS employed CAs. They had the budget to employ top qualified people. Sadly, and because of various public service and other salary curtailments and so on, SARS do not have the same resources that they might have had. And I think they struggle from that point of view. And therefore, when it comes to efficiency, and look, let's all be honest about it. If there are to be resources at SARS, they're not going to be devoted or prioritized in favor of people who have left South Africa. Why should they? There are other priorities within the organization. So there's a concern, and it's a widely held concern, that if you are in the hands of SARS, then you could be in for a long wait, just in terms of the processes and so on, and the systems that are in place. So not necessarily just in relation to getting your RA out. And one of the questions, and we'll touch on it towards the end, is what about inheritances? Because currently inheritances are remittable under the current regime. And if you've emigrated and you lose a relative who's thought upon you kindly in their will, then provided you've emigrated, you can receive your inheritance quite freely in your new country of inheritance, your new country of residence. So the question is, what will happen next? And it would seem, from what we can understand, and this may be the topic of another one of these webinars once the letter of the regulation is made known, but we'd be less in the hands of the Reserve Bank and more in the hands of SARS. And that is just how it's going to be. So people, insofar as their retirement funds are concerned, and if they are eligible in terms of the age, it would seem are trying to do it and deal with an organization like the Reserve Bank and not have to see what the efficiency levels of SARS may be at a time in the future. So how do you, having just said that you are required to show or prove to SARS that there's an uninterrupted, you've been not or non-tax resident for an uninterrupted period of 3 years or more, how do you demonstrate this to SARS? And in fact, how do you cease to be a tax resident? What are the formalities? And Rob, when he chats to us later, will tell us about the resident rules. What are the rules in the definition of residence definition of residence in the Income Tax Act? We'll talk a little bit about how the DTA double tax agreements come into play. But in simple practical terms, you cease to be a resident, and there's a process for informing SARS of that fact. The problem is that it's only from 2017 onwards that a question arose and appeared for the first time in the individual income tax returns that one has to submit to SARS. And it's in that initial, they call it the tax wizard. So if you are an accountant or an auditor or a professional who assists clients with tax returns, you'll know exactly what I mean, or perhaps you do your own tax returns. In what they call the wizard, which opens up with, where you state if you're a director, because then it'll open up assets and liabilities, or if you've got investment income, it'll open up the section for interest received. And there's a question that says, did you cease to be tax resident during the tax year? And the question is framed in an unfortunate way, because what if you ceased being tax resident in another year, in an earlier year? You can't say yes, because then you're not answering the question properly. So it seems that that question is perhaps a little flawed in the way it's designed. And so it's fine if during the 2018 or any subsequent year, you cease to be a resident, you would check that box. And then on that basis, you have, and you can always show that you've officially informed SARS that you are not tax resident. But what do you do if you've ceased to be tax resident prior to 2017? And how do we advise SARS? And it's important now, as you'll see, because we need to show that we need to at least been out for the period of 3 years or more. So one of the ways I would suggest is that you write to SARS, and the SARS website has 2 email addresses. One if you're writing personally, or if you're a tax practitioner, and you simply write to SARS to say that you've ceased to be tax resident. And I think you would, to your email, just attach some or other form of proof, the sort of proof that SARS would expect, and that is perhaps the citizenship citizenship certificate or passport of your new country of residence, a proof of residence, rates or electricity or some utility bill, and then probably, and this one would trump everything, if you can get from your the tax authority that you're currently paying tax to, some or other certificate that you are in fact tax resident in that jurisdiction. And on that basis, you would advise SARS. So one of the topics, and I think most of us are probably familiar with this, so we can perhaps go a little more quickly. When you cease to be resident, and you've communicated that to SARS in the manner that I suggested in the earlier 2 slides, then there is, if you've left since 1st of October 2001, there is a deemed disposal for capital gains tax purposes. And we call it an exit tax. There's a similar tax in America, for example, and you pay your tax on the assets as you leave. There's almost an element of reciprocity, because the country that you're leaving South Africa for those same assets become a base cost in your new country, and when you ultimately dispose of them, not on a deemed basis, but an actual disposal, then you would most likely to have capital gains tax implications in that new country. For South African capital gains tax purposes, and by the way, those of us know that if we want to read up all the rules in relation to capital gains tax, they're contained in the 8th schedule to the Income Tax Act. And there are assets that are subject to CGT, and there are assets that are not subject to CGT. So generally, the assets that are subject to CGT, so there are excluded assets like your personal effects, your motor cars, your boat, and then the other sort of more significant asset that you're likely to own, or possibly at the time that you cease being tax resident, is a property, either your own home, or which may be a primary residence for tax purposes, in which case the first 2 million of the capital gain is exempt, or an investment property, perhaps a property at the coast or somewhere else. And provided you own those properties directly, you're not subject to CGT when you cease to be resident, quite simply because you will pay the CGT when there is an actual disposal. So there isn't a deemed disposal. So those are assets that are not subject to CGT. I was possibly confusing myself. So properties that you own, primary residence, investment properties, commercial properties in your own name are not subject to CGT. Section 8 deals with properties, and this was an amendment back in 2013. So for the first 12 years of CGT, everything was hunky-dory, and properties generally, whether held directly in your own name or indirectly through an entity, a company, a close corporation, was not subject to CGT for the same reason. And then Section 9H was inserted in 2013, I seem to recall, where if you hold a property via a company, then that is a deemed disposal in terms of the value of the shares or the members' interest in that company or close corporation, as the case may be. And there could be a nasty sting in that, because ultimately when that property is disposed of by that entity, you could almost contemplate a double whammy, a double element of CGT. So just be careful. And in favor of not immigrating at the moment, and some people that I'm aware of and that have spoken to me, is that they have properties, but they're all in companies and so on, and they would suffer a huge hit in terms of CGT. And bear in mind, what makes it more painful is that it's a tax liability on a deemed disposal. So you don't have an actual liquidation event where there's money coming into your bank account in order to pay the CGT. You have to fund the CGT yourself from your own resources, because you haven't sold anything, but yet it has triggered a deemed disposal. So when is CGT payable? An interesting question we get, because you may leave. Do you have to pay CGT before you go? No. You pay CGT in the year in which you cease to be resident on a deemed basis. And then on that basis, and as we're in February, so let's say anyone that ceased to be resident in the 2021 tax year, those returns will only be submitted when SARS e-filing season starts. Last year, because of COVID, it was delayed till August or September. Usually the SARS e-filing system opens on the 1st of October, 1st of July every year, following the 28th of February. And just remember that you may need to account for that CGT in your provisional tax payment or that of your client, which is coming up in 10 days. Right, we move on to one of the other topics, again, discussed to a large extent in the previous presentation, but just still relevant, and it is repeated here, but perhaps from a more practical point of view. So there was this, the rage of last year, and much written about in the lay media and the social media, like what they called hashtag 2020 expat tax. And in my entire career, I'd never known of a tax to become so popular that it acquired a hashtag. And this was all about the exemption that was contained in Section 1010 of the Income Tax Act. The background to the exemption, just very briefly, is that a number of years ago, SARS, it was after 95, 96, South Africa was opening up, and South Africa wanted to be competitive. And it was the construction industry that approached SARS in that instance and said they wanted to be able to pitch for projects in Africa, in the Middle East. And it was hard to find employees to go and work in the sticks away from their basic home comfort. So SARS listened to them very intently and very generously provided for this exemption. They couldn't call it the construction industry exemption because SARS would have then had at its door every other industry lobbying. So they made it a general exemption where employment took place outside of the Republic, but for a South African employer. And there was the basic requirement, which is remained unchanged, and that is 60 days continuous service outside South Africa, 183 days in aggregate. So obviously it envisages that particular individual coming home to visit his family or whatever from his particular tour of duty. And that is measured in any 12-month period. It didn't necessarily get driven by the actual tax year. It could be any 12-month period. Then in legislation, when SARS were really, like most governments around the world, were looking for additional money, they revisited this exemption, felt it was way too generous, didn't quite see the need for it, and announced the intention to withdraw it. And there was a huge outcry for a whole variety of reasons. So initially, in his budget, Tito Mboweni announced a cap of $1 million, but within weeks, his hand was probably, his arm was twisted, and he increased that exemption from $1 million to $1.25 million. And that exemption applied from the 1st of last year. And it's important to note, and we'll see why in a moment, that that is only relevant to residents. And obviously we're talking now about tax residents of South Africa. I should also just mention, in terms of the 60-day and the 183-day rule, is that, and this is all set out on the SARS website, because of COVID, SARS was sympathetic that people may not have been able to travel. There were the impact of the Disaster Management Act, the lockdown at the various levels. And so the period or the requirement due to COVID was relaxed slightly, and I think just for a particular period when the impact of COVID was at its greatest. So, you know, why the fuss, the hype, and the reality is that the exemption only applies to South African tax residents, as I said a moment ago, and there was this presumption out there, fueled very much, you know, by the lay media and so on, that SARS could then effectively, and that's why it was called an expat tax. So if you were a South African expat now living in the UK or in Dubai, and the exemption no longer applied, SARS, so it was assumed quite incorrectly, SARS could come and tax you in your country of residence, as ridiculous as that may sound. You know, I was amazed, frankly, at the extent to which this hype was allowed to continue, and the amount of misinformation. It also, in fact, in my view, was one of the reasons why Tito Mboweni last March decided to abolish the concept of immigration, because many advisors out there, I wouldn't even call them my colleagues, I don't think they're worthy of that honor, we're encouraging people to say, if you want to beat the expat tax or make sure that SARS cannot come and track you down in the UK or Dubai, and examples I mentioned earlier, and tax you, well, you should financially immigrate. That's a clear way you can show that you're not tax resident. I mean, what utter nonsense. So, and I think that it was from then that the authorized dealers started being inundated, driven by these people, probably out of self-interest, because they were all in some or other business selling the service of financial immigration. And I think many people financially immigrated who were under the law and the DTA, clearly not resident, and therefore under no stretch of the imagination could they be liable for this so-called expat tax. And you know, the DTA, even if it wasn't clear, because as I mentioned earlier, you hadn't told SARS that you weren't tax resident, under the provisions which Rob will inform us of shortly, or even under the DTA provisions, that you know, those were totally ignored, and therefore this huge consternation was allowed to prevail. And I saw it firsthand, because I was contacted by people abroad, people who'd been abroad legitimately and not resident for many, many years, you know, asking whether they would conceivably now be taxed. Right. I think, Rob, I think we've got to that point in the presentation where we've covered exit tax, we've covered expat tax, and I'm going to ask Rob just, again, fairly briefly, just to remind us, because it's all relevant, on what rules, both in our law, determine tax residency. Rob.
Thanks, Ernst. Thank you. And thank you all again for listening in today. I'm going to jump right into it purely for timing purposes, and my notes on this section will be circulated to you all directly afterwards. It's important to clearly define one's tax residency status because, quite simply, the taxation of a South African resident differs from that of a non-South African tax resident. The key difference, simply put, is that a South African tax resident is taxed on their worldwide income, which is, of course, their South African sourced as well as their foreign income, whereas a non-South African tax resident is only taxed on their South African sourced income, obviously subject to certain exemptions. So when is an individual considered to be a tax resident of South Africa? A resident is defined in the Income Tax Act, and I'm paraphrasing as much as possible, as any natural person who is ordinarily resident in South Africa during the year of assessment, or, failing which, meets all three requirements of the physical presence test, but does not include any person who is deemed to be a resident by virtue of the application of any double tax treaty, and I'll unpack that shortly. By implication, of course, a non-resident for tax purposes is therefore any person who does not fall within the definition of a resident in the Act. So let's delve into the three tests in a bit more detail. First is the ordinarily resident test. The term ordinarily resident is not defined in the Act, and the test is a subjective question of where the person intends their true home to be. It's the place to which a person would naturally return from their wanderings. It's clear, therefore, that no single factor alone is capable of determining the test of ordinarily resident, and therefore each person's particular circumstances must be considered as a whole. Things like your rights of residency, economic interests, personal effects, and whether or not you've formally emigrated are considered, amongst other things, in the ordinarily resident test environment. Second is the physical presence test. It's often referred to as the days test. So unlike the ordinary residence test, the physical presence test is an objective one. A person who is not ordinarily resident in South Africa could still be regarded as a tax resident in South Africa in the event that all of the following requirements are met. So let me just repeat that because you guys don't have the notes in front, but a person who is not ordinarily resident in South Africa could still be regarded as tax resident in the event that all of the following requirements are met. Now, this is the days test. So they spent more than 91 days in South Africa during the current tax year. They spent more than 91 days in South Africa during each of the immediately preceding 5 tax years. And they spent more than 915 days in South Africa in aggregate over the preceding tax years. Now that seems complex, but when we start applying it to actual scenarios, it'll become quite clear. It's important that all 3 of those tests within the physical presence test must be met for a person to be considered physically present. Third is the review of a double tax treaty. So the treaty, if applicable, can override the ordinarily resident test and physical presence test. However, an analysis of the treaty is generally only required when the person is regarded as a resident of both countries under their domestic laws. The so-called tiebreaker provisions of the treaty are then analyzed in determining the person's tax residence. These tiebreaker provisions typically include where the person has access to a permanent home, where their center of vital interests are, etc. It's clear that each case obviously needs to be analyzed individually because certain jurisdictions may not have a double tax treaty in place. I hope that gives you a high-level understanding of the rules, and I'll now hand back over to Anthony to cover the final sections of the talk. But we will, as mentioned at the outset, be available to answer any questions you may have at the end. So thank you very much.
Thank you, Rob. Well done. I just used the opportunity just to have a peek at the questions. And thank you to the 4 of you who've submitted questions. They're very interesting questions, and I would recommend, in addition to some of the other questions we had previously, which we'll deal with, anyone else with questions, feel free to post them in the Q&A, and we'll gladly deal with them. But some interesting, certainly the 4 that have been submitted thus far, for which I thank those 4 that sent them, are indeed quite interesting. So we're nearing the end of sort of the final section, and I just have to see why my sorry, I'm just going to stop sharing for a moment. Seem to have a problem with my slides. Just bear with me. Slight technical problem. Chat amongst yourselves. Okay. Right. I've now got it. So let me reshare the screen. Okay, so if I minimize, there we go. In the month of February, and there's some issues that we've come across that we thought we would draw your attention to. They are normally very mundane and would be outside the scope or the realms of any particular tax seminar or exchange control seminar for that matter. And that's and there's a reason we draw your attention to them, is because they go hand in hand with a lot of what we've been discussing during the course of this afternoon. So, and that really is all about the remuneration source codes. And just to acknowledge him, my colleague, Nino Muscolino, who's also on the panel, is an expert on these. He administers a number of payrolls, both that deal with normal remuneration, and in fact, many of South Africa's talent who get to perform on stages around the world have their payrolls administered by Nuno. So he's well versed in the subject. So your normal stock standard salary source code is 3601. If it is, however, a salary that is exempt under section 1010, then the required source code is 3651 instead of 3601. And this has changed somewhat in terms of the SARS treatment over the life of the existence of section 1010, as to whether it's subject to PAYE or not. And there were, in the earlier days, SARS said if the employer was satisfied that the requirements of section 1010 were met, they could refrain from deducting PAYE. But I think at the end of the day, and possibly because there was abuse, the 3651 code is subject to PAYE. Obviously, that is when the exemption would be applied, and that would all be done on the completion of the tax return, and any PAYE that was withheld that is in excess of the actual tax liability would then be refunded. And then there's a situation, we're going to deal with this under question time, and that relates to where you have a salary, and it relates to Article 15. In some other DTAs, it's Article 14, but it's under the heading of dependent personal services. So someone who's in an employment situation, but where the employer is in one state, the employment is exercised in another state. So, for example, South African employer, the employment is exercised, say, in Dubai, and In terms of the way this particular Article 15 is worded, that in terms of the double tax agreement is foreign sourced income, but not taxable in South Africa by reason of the DTA. And I should just mention to everyone that double tax law, or treaty law, as we would call it, trumps or overrides any provisions, any domestic provisions in the income tax laws of any country, and in particular South Africa. So there would, in those circumstances, it would be appropriate to use a 3652 code and no PAYE in those very few and limited circumstances would need to be deducted. Thanks, Danny. I see you're sharing let me just get the next question on. So I just want to get back my screen where I can see. All right.
I've stopped sharing, so you can, if you need to carry on. I'll just try to bring it
let
back
me
when
just
you're
see,
having
it was
an issue.
hanging. Let me just share again. Right, let's just get the slideshow going again from the current slide. There we go. Sorry, Danny, I may call on you again, but let me just see if I get it right. Share screen. There we go. Share. Right. Is that slide being shared, Danny or Stan?
Yeah, I see it now.
Okay, great. All right. So I mastered the technology. So this came from one of our delegates, our attendees today, and there are 3 questions, very interesting practical questions, and I may look to my panel, so have your fingers on the mute button. But so in this instance, the client is a British citizen. Okay, so there's that point I made earlier on. So citizens of other countries, because they're permanent residents, are then still regarded as residents for exchange control purposes, and indeed for tax purposes. This person came to South Africa about 7 years ago with her husband. She has permanent residence, and she's now gone back to the UK. So we hear there's some confusion over the sale of the house. The conveyance insists that she's a resident at the time of transfer, not resident at the time of transfer, not present in the country when transfer happened. So there's a disagreement between the conveyance and the tax practitioner, who claims that she is a resident. Why the conveyance is getting involved, for those who may not be aware of what's being discussed here, is that in terms of our conveyancing laws and declarations that are required by purchaser and seller, the declaration as to the residence, if a seller is a non-resident, this is for tax purposes, not for exchange control purposes, then there's a withholding tax, which came into being a few years after capital gains tax was introduced. I suppose they felt that a non-resident would sell a property, remove the proceeds from the country, and then poor old SARS would have to whistle for the capital gains tax. So not is the case nowadays. There's a withholding tax, and SARS will then do a assessment and refund the amount or the excess withholding tax that has been deducted, but the obligation is on the conveyancer. So yes, Rob, thank you. You've had a look at this. Could you deal with both parts to question one?
So I'll handle the first section first, where the question's actually asked. And I think this is kind of squarely in the days test arena. Let's just look at the days test again and apply it. So when does she become resident or non-resident in terms of the physical presence test? The last 5 years she has been present, but has no intention of coming back. Okay, so, I mean, obviously we have to look at exact dates here, but let's, for the purposes of this, assume that she fails or she is considered to be physically present, i.e. she spent, he or she, so she spent more than 91 days in South Africa during the current tax year. She spent more than 91 days in South Africa during each of the immediately preceding 5 years, and then she'll, by default, would have spent more than 915 days in South Africa in aggregate over the 5 preceding tax years. So let's assume that, according to those tests, she is physically present. When you talk about her intention and has no intention of coming back, that's more of an ordinarily residence test, and we'll get there. But there is a provision in the definition of a resident, which I didn't cover in the presentation, which, and I'll read it to you. It says, where a person who is a resident in terms of the subparagraph, where they list the 3 days test, is physically outside the Republic for a continuous period of at least 330 full days, immediately after the day on which such person ceases to be physically present in the Republic, such person shall be deemed not to have been a resident from the day on which such person so ceased to be physically present. So let's assume that she falls on the 5 years, okay, which would deem her to be physically present and accordingly a tax resident in South Africa, notwithstanding her intention of not coming back. Because remember I said, even though you could be ordinarily resident somewhere else or not ordinarily resident in South Africa, if you fail or if you are physically present, the physical presence test deems you to be resident in South Africa. But in this situation, if she's left and she spends a period of 330 full days after the 5 years, then she could be deemed not to be tax resident by virtue of that provision. What I think also should be looked at closely here is the possibility of the double tax treaty. Unfortunately, don't have it in front of me, but you know, what could happen is that depending on her specific circumstances, she could be deemed exclusively to be a citizen of either the UK or possibly South Africa, and that would override the days test. But I'm happy to take this chat offline with whoever the person was who sent it. Let's have a look at the specific dates involved, and I can give you a more refined answer.
Thanks, Rob. We do have that person's details. She was very proactive in sending the question in several days before, so that person, and you know who you are, we will be in touch with you just to make sure that we've answered your second one is a really interesting one and so topical to this particular webinar. Is she required to do financial immigration though she's a British citizen? And the answer is yes. Well, if she decides to do it before the end of February, and presumably you have already your MP336 all completed and ready and signed and ready to get it in, and you were just waiting for the answer from this session, she would be. So the fact that she's a British citizen, and remember I said earlier on, you can still be a citizen of any country but you're a resident of South Africa for exchange control purposes because she came and lived here. She immigrated. I think the first part of your question actually tells us the facts. She immigrated, IMMIG, immigrated to South Africa 7 years ago. She retained, obviously, her British citizenship, and now she's leaving. So in as much as she immigrated, she now has to emigrate, but obviously needs to do so quickly. Getting the money from the sale of the house back to the UK, well, Rob, I think you probably know the answer to that one. You do it every day for our clients.
Yeah, so I mean, that's depending on the quantum involved. We're saying no CGT is payable. If it's under R1 million involved, the money can be exported using a single discretionary allowance. If it's more than R1 million, it can be exported using her foreign investment allowance, which is subject to an FIA, foreign investment allowance tax clearance certificate, which is a specific type of tax clearance which is applied for on SARS e-filing. The CGT calculation will be provided. Some of the other requirements is a 3-year balance sheet of the last 3 tax years. You've got to show proof of source of the funds. And once she has tax clearance, she can remit those funds offshore.
Question 2, it's a short one, but it's also very poignant and to the topic. I might ask Mike if you're there. When does someone have to financially immigrate? Well, do they? That's what we've been asking ourselves all day. And what factors to consider to do it or not? I think I've covered that. And I hear it's a problem for getting an inheritance offshore. Well, Mike, do you want to help this same person as question 1, who's put a separate question in question 2? You're muted, Mike, if you were... are you okay to do it? Otherwise, I can jump in. All right. Let me do it.
Technical issues, and
yeah, okay, no problem. When does someone have to financially immigrate? Well, you don't. And that's why so many people over the years left and didn't, and they just remained in that expression, somewhat inappropriate, South African resident temporarily abroad. Well, you can have been temporarily abroad for 25 years. So what distinguishes a South African resident temporarily abroad with an immigrant? It is the mere completing of that MP336 that converts you from a South African resident temporarily abroad to a non-resident immigrant. So I suppose the answer, and you'd be thumping the table if I say, well, you know, you don't have to financially immigrate, is, well, if you were under 55 and you had an RA, and you wanted your money out now, and you were worried that SARS would take their time, or you perhaps have recently emigrated or relocated, and you're impatient. You want your money now, and you don't want to wait the 3 years. Well, then, you know, before the 28th of February, financially immigrate. So those are the factors that I think you would ordinarily consider as to whether to do it or not. Now, your question is a very appropriate one. I hear it's a problem for getting inheritances offshore. So if someone hasn't immigrated and they inherited prior to the 28th of February, then they're not forced to financially immigrate because they still have, as Rob indicated a few months ago, and I'll repeat, you have your SDA of $1 million, or you have your FIA of 10 million. You just need tax clearance for the FIA. So, but the magic of an inheritance in the context of immigration is that if you had immigrated and you then inherit. A great aunt suddenly remembered you in her will. On the basis that you can simply provide the executors with your immigration details, they will then submit to the bank, to the deceased estate bank, a copy of the will, copy of the liquidation and distribution account, showing your share of the inheritance, and the fact that you are a non-resident immigrant, and those funds would flow almost automatically. So yes, if you haven't immigrated and you've inherited, yes, there would have been a problem. It's not impossible. There may have just been a delay, because it might just be if you were out of the country and for more than 5 years. I mentioned that earlier. You wouldn't, in order to get a foreign investment allowance, the requirements for a 10 million foreign investment allowance, in the case where you haven't immigrated, is you must be a taxpayer of South Africa in good standing over the age of 18. And on that basis, you can apply for tax clearance, and you'd be able to take your inheritance out. I hope that. Hello, Mike.
I can't tell.
Sorry, Mike. Okay, he's muted himself. Right. This, I think, is the last question before we get to the other questions from the floor. Then more simple scenarios need looking at, just like a normal SA citizen moving offshore. When do they still need to submit SA tax returns up to? I guess the first part is really got less to do with immigration and more to do with tax. So, and I think here's the question, if I can put it crisply, is at what point do you continue, you've left, you've ceased, as in the way Rob explained, you've ceased to be tax resident. When do you, or for how long, or under what circumstances, do you still need to submit your tax returns to SARS, and up until when? Well, the requirement to submit tax returns is really driven by whether or not you are in receipt of taxable income. And Rob made the point, and I'll just repeat it, that if you're a non-resident, you're just taxed on South African source income. So you may not have any. Even if you earned interest from a bank, there's an exemption contained in Section 10, where if you're non-resident, you're exempt from interest on a bank account. So on that basis, you would be entitled to write to SARS in the way that I described earlier, and ask to be taken off the mailing list, and you would no longer then be required to submit tax returns. And if at a later stage you are required to, then, and the process is quite simple, it's all done online, you can register, or you can come back into the system again with no major questions asked as to where you've been all these years. So yeah, that's what will drive how long you remain tax registered for, how long you're required to submit returns. And what many people do is they will continue to submit returns, but just submit them as null returns. But it's important to tell SARS that you are no longer tax resident for a number of reasons. Do they need to financially immigrate? I think I have covered that probably in a fair amount of detail as to when one would and when one wouldn't. And now there's my situation, the youngster with no balance sheet versus the more mature person with a balance sheet. In fact, if a person, so the youngster with no balance sheet is many people who left after they were studying, finished their studies or whatever, they have no assets. They, in the past, probably didn't need to immigrate unless they were going to inherit. So we linked to that previous question. because they had no capital to export. Maybe it was a question of closing the pigeonhole and just putting it on record, but for that particular person, there would have been no real reason to immigrate. Somebody who is more mature with a balance sheet, I find today most of the people with balance sheets are youngsters, but that's by the by. That particular individual obviously has assets, and if they decide to immigrate, it's quite a process. Then everything that I said for the first hour on the MP336 would apply if they decide to do it before the end of the month. And as they say in Afrikaans, jy beter gou maak, because time is running out. So again, if you don't immigrate, then you must just take your chances with SARS after 1 March 2021. Here's the DTA question I alluded to earlier, and the DTA in place for more common places like UK, Australia, Dubai, and there is this, and this is all to do with that Article 15, or I think it's 14 in the case of some of the other treaties, just the numbering, and that is where the exemption, so employment for a South African employer is exercised in a country other than South Africa. And there are, in that dependent personal service article 2, there's an A, B, and C. All three have to apply. And from memory, they are A, you have to have been out the country similar to the 183-day rule. So you have to have been out. So it wouldn't be taxable in South Africa if you've been out more than 183 days. The second one would be if your employer, or provided your employer doesn't have a permanent establishment in the country in which you are now resident, or where you are exercising your employment. And the third aspect is whether your employer gets a deduction for your salary in that other country, because on the basis of some presupposed symmetry, if there's a deduction, then South Africa, if South Africa is giving a deduction, it wants to get the tax. But if all three of those requirements are met, in other words, out for long enough, no permanent establishment, no deduction claimed, then the wording, and this is very interesting, and if you've studied international tax, the DTAs, they talk about may. So does that mean tax is voluntary? I don't think so, but it says it may be taxable, and in this particular, in the context of question 4, it may not be taxable in South Africa, but in the other country, like UK, Australia, or Dubai. So, right, before I give you our forthcoming attraction, I think we've come to the part where we are free to take your questions. They've risen in number, they've almost doubled. And again, I thank you for those 10 people. Perhaps I'm not sure, are they visible to everyone in this, on their screens? Okay, so the first question, you're entitled to an element of anonymity, so I will read the question without reading the name of the person, but thank you for the question, because they're all good questions, and that's what I find is the most rewarding about the commitment of my time to this, is the feedback that I get from you by way of your questions. How can a beneficiary have his funds remitted abroad if one has not financially emigrated? So the question is quite simple. So this is someone who receives an award or distribution from a trust is a beneficiary. I'm assuming it's in a trust and not from an estate, but it would apply equally from a deceased estate. And quite simply, you have available, so I must make an assumption here because the question doesn't say, if that person is not tax resident, let's make that assumption, because they want to remit them abroad, then we're looking here at the foreign investment allowance, the 10 million, and it would require tax clearance. I think that would be the answer to that. Feel free to add additional question if we haven't answered completely or perhaps missed it. The next question, and this is from somebody who I will name, it's a Mr. or Miss Anonymous attendee. Do the formal immigration rules regarding RAs differ for someone over the age of 55? Person is still ordinarily a tax resident in South Africa, but with the intention of emigrating within the next couple of months. So this is a brilliant question because it is just so pertinent to what we've been discussing all along. And there's almost a bit of a prejudice, and we should almost go to the Constitutional Court on this, because the prejudice is in favor of someone under the age of 55, compared with someone over the age of 55, like I am. That person, so emigrating, there aren't different formal immigration rules. What that just means is that you then deal with you come out of that fund not under the withdrawal rules, because under 55, in terms of the Income Tax Act and the various rules that regulate that, are to do with withdrawals. But over 55 or 55 and over, you are into the retirement space, and there you can commute perhaps 1/3 of the fund and take that in a lump sum, and the balance you would need to purchase an annuity. So the modern way of doing that is you look around for a living annuity. All the life offices offer them, and if you're thinking of emigration because you've stated that that's your intention, then what you do is you crank it up to the maximum permissible amount from a living annuity, which is 17.5%. And you just hope that you get the bulk of your capital out in that manner. If you're worried about the rand possibly depreciating, then make sure that the underlying portfolio of that living annuity is in good rand head stocks. And somebody who is phase approved will be able to advise you on that very easily. The next question, for CGT exit tax, if one has a CC, that's what I mentioned in 9H, which has to be valued, and the member has a debit loan account, which makes up the major value of the CC, would the liability in the hands of the member be set off against the value of the CC? That is an interesting one. So in other words, so it's a 10-1, and I'll just pull out, because I have it handy. The exit would consider to movable property interest, and these will, so it's a direct or indirect shareholding of a minimum of 20% in a company ownership or right of ownership in any other entity. If more than 80% of the market value of the entity is attributable to South African immovable property held otherwise than in trading stock. So in other words, if it's a capital asset, then it seems on what I've just read here, you look at, you attribute the market value to the shares or the members' interest in this instance. So it would seem that the liability in the hands of the member, it actually makes sense, because I think what you're asking, this is really just a capital gains tax question, is if I've got proceeds, because there's a deemed disposal, can I mitigate the value by the fact that I've got a corresponding liability? And I would suspect not. What I would do, if you'll get, we'll give you a more informed answer to this question, is pop us an email, as you've answered the next one, ask the next one as well. But the person who's asked that question can, we will answer it with pleasure in writing, or just give Danny your email address, we can get it from Danny. Let's just deal with the second question. Once financial immigration is abolished, will there still be blocked bank accounts? And if not, what will happen to existing blocked accounts? We were hoping to have the answer, the real answer, and I'm looking at Mike, because this is his field. We actually don't know. I mean, there's a whole regime and that has to transform or morph into the new regime. And we don't know at this stage. It will be known fairly soon, we hope, because we're running out of time. And we will certainly keep you in the loop. Stay in touch is what I would suggest. Right, here's a nice question with some nice examples. Someone who works in ATC, what is that? An air traffic controller. 2 years working in Baghdad. As a result of COVID, this person is back in South Africa and now unemployed, and staying in the property which he still owns and where he still has all his dogs. He's been told that because he's been out of the country for more than 183 days in each year, he isn't liable to file tax returns in South Africa. I don't believe that's. Is he regarded as being non-tax resident for those 2 years? I'm thinking he's tax resident and should be filing. So based on what Rob told us and applying the facts of this question to that, I think in those intervening 2 years, he would be tax resident. And it isn't that easy to flip in and out of tax residency in South Africa because of the way the definition of residence in those 91 days and the 5 years is constructed. So you're saying, and in brackets, I'm thinking he's tax resident and should be filing in South Africa. I'm saying to you, Mr. or Miss Anonymous Attendee, I would tend to agree with you. I think you're 100% correct.
And if I can just add to that.
Yes, Rob, go for it.
And I think what should also be applied here, because the delegate mentions the fact that he's still staying in the property which he owns and where he still has all his dogs. Now, that may seem kind of immaterial, but when you're looking at the test for ordinarily resident,
yep,
it's factors like that come into play. You know, yep. Does he still consider that his permanent primary home? And if he does, notwithstanding how many days he's spent outside of the country, he could still be deemed to be South African tax resident from an ordinarily test point of view.
I agree, and in fact, it's quite interesting that in this question, the aspect of the pets has been posed, because when one ceases to be resident when one relocates or migrates, it doesn't necessarily, and you would have seen this by now, signify ceasing resident or becoming tax resident in the new country. And I often, and part of the ordinarily residence test is, and I often used to say to clients as a test, if you move and you're unsure, it's when you call for your cats and dogs and have them join you in your new country that I think you say, here we are. And so the mere fact that the dogs remained, hopefully during the 2 years they were well cared for and someone was feeding them. But yes, I agree. I think that you're absolutely right, Rob. Another question, I'll just go through it quickly. I have a similar question to question 1, please. Client left December 2019, never set foot back in South Africa. He's gone to the UK and working there since December 2019. Is he still required to submit a tax return as a resident in South Africa? Will he be subject to the 1.25 exemption if he was earning income in the UK? Please advise if possible. Brilliant question, because it's just, again, so relevant to what we've been talking about. And that is left in 2019, not come back, probably in his 2020 return. And if you're the tax practitioner, because you're asking, is he required to submit a tax return? So I think for the 2020 year, he would. And that's the year that you would, in the wizard, in that earlier slide, where you would check that box, have you ceased being tax resident in the year? I think you would most definitely make a cross in that box. Okay. So he's gone to the question then relates to his post-December 2019 income. Is he then subject to the 1.25 exemption if he was earning income in the UK? Well, he wouldn't get the exemption because he's not a resident anymore. But that doesn't mean he's going to be taxed in the UK. He's not going to be taxed in South Africa on his UK income because the UK double tax treaty would have that provision that Rob mentioned in the proviso to our domestic provisions that says in any situation where if you're tax resident under the treaty in one country, you then wouldn't be tax resident in another country unless you start going into tiebreaker tests and you have center of your financial and economic activities in another country. But under the rules, and as simple as you've put it in this question, that person would be tax resident in the UK. So he wouldn't get the 125 exemption, but he wouldn't be subject. I wouldn't even reflect for the months of January and February. I wouldn't reflect his income because he's not tax resident, taxed on a source basis only and no worldwide income. So thank you for that, and that's the question. My client is in the process, is the next question, of taking up employment in Saudi Arabia with effect from April 2021 for a 5-year contract period minimum. His wife and kids will join him in September 2021, so a couple of months later. He has a pension fund that will need to be transferred to a preservation or to be paid out. Will he be eligible at this stage to apply for financial immigration, even though he's still in South Africa and will be able to get his pension fund paid out to him now? So presumably his employer would have agreed to release him. I'm going to make an assumption here that he's under 55. So because he's got a wife and young children, I would believe. And so this is, again, an excellent question. And I mentioned it earlier on in the MP336 on the date of departure. And I think that if you have, he's taking up employment in April 2021, the authorized dealer, in my view, will accept that MP336 now. on the basis that he's leaving in just a few months' time. It's March, April, definitely. In terms of what we've been told, it's in that window. The authorized dealer would be quite happy with that. Just check with them. If they disagree with you, tell them they will have to deal with me. And yep, you can certainly go ahead with the process. Okay. Then the next question again was a person who's financially immigrated years ago and is receiving an annuity from an RA. Is this annuity taxable in SA? Excellent question. So if you look at the double tax treaty, and it depends where that person is resident in. And I'll give you an example of, excuse me, either UK or Australia. What the treaty says is that if you provide, and unfortunately you have to do it, we've got a client in the UK, and it's a pain because you've got to do it annually, you get a, and there's a, Ryan isn't on our team, Rob, I don't know if you know the SARS form, but it's basically SARS's way of certifying that, so you first get a, you get a certificate of tax residence in the country, and then you take it to the insurance company that is paying the annuity, and on the basis of that, they will get a nil tax deduction directive. So that's on the PAYE side, and it follows, and the reason that SARS will give you that deduction is that the annuity is not taxable in South Africa, but you'll probably find the way that treaty is worded is that that pension or that annuity may be taxable in the country to which that person has emigrated to. It gets a bit complicated because if it's a living annuity, you've got to analyze, because a portion of a living annuity has a capital element and an income element, not to overcomplicate it unnecessarily. So, but as a general rule, you asking, is it taxable in South Africa? And I would say, if you look at the country and you look at the treaty, then the answer is no. Here's another anonymous attendee. If a sole proprietor, a tax practitioner, emigrates to the UK, but continues practicing with existing clients, would SA tax residency cease to exist? Very, very, very interesting. I've checked the rules as a tax practitioner and the requirements in terms of the Tax Administration Act. There isn't a requirement for a SARS tax practitioner to be a South African tax resident. And therefore he can continue, because working remotely, he can continue practicing with his SA clients. Would SA tax residency cease to exist? I would think that it would, because he would probably fall under the UK. He would be a UK tax resident, and under the treaty, and I think by reason of the treaty, his SA tax residency would cease to exist, is what I believe would be the answer there. Here's another one, left in September 2019. Looks like 2019 was a good year for people leaving. Well, they couldn't leave in 2020. There was COVID. A taxpayer left South Africa permanently. So I'm thinking of Robert's 330 days story, for the Netherlands with no intention of returning. So all sorts of things, the subjective test of ordinary residence come into play here. No intention of returning. The taxpayer is employed in the Netherlands, but is allowed a lower expat tax rate in the Netherlands for a period of 5 years. Would Section 10(1)(n) still apply, and will financially emigrating before February 2021 be recommended? So 10(1)(n), I'm not sure. Are we talking about 10.10 and that's just a typo? Let me assume that it is, because otherwise, why would it be relevant? So yes, the fact that the Netherlands, as a welcome or a tax holiday or applying an expat rate for a 5-year period, isn't the fact of the matter here that he left permanently and we're told he has no intention of returning? Hasn't he ceased to be resident in South Africa? And when he does his 2020 tax return, he should check the box in the wizard. And by the way, even if he omitted to do that because he wasn't aware of it, didn't know that, you can go back to SARSI filing and request a correction. We did this recently, and you can go back and uncheck that box, or rather check the box, sorry, if you omitted to do it. And then, and will financially emigrating be before February 2021 be recommended? Well, we don't know what his other assets in South Africa are. Is he asset rich? But let's assume that perhaps he's got the proceeds of a house or whatever. Then he probably would be. It would be worth emigrating on this basis. The fact is he's left, and yeah, we'd need a bit more information. And the person who's posed this question is welcome to give us more information in the email. But I would say, so would section 10.10 still apply? I'm assuming it's a typo. No, again, because I've concluded that he ceased to be tax resident. So it's, again, I'm glad this question is being asked, and it enables us to say repeatedly, when we did with that section on expat tax, that for 10.10, for the exemption in 10.10 to apply, you need to be a tax resident. And everything that I'm hearing and reading into this question is suggesting to me and to others that he has ceased to be tax resident. But it's irrelevant, because the Netherlands would have a double tax treaty with South Africa, and therefore would dictate, even though he gets the lower expat rate, he's still nonetheless tax resident in the Netherlands, I would submit. Right, we've had a lot of support from this one person who I'll continue not to name. Just to clarify on your question 4, if a member is employed by an SACC and therefore the CC claims the deduction, but the member is permanently living in another country, would his salary be taxable in SA or not? So that person, so the CC claims the deduction because that person presumably is rendering certain services abroad, but for that South African CC. And these might be, though it's a CC, if it was a director, it would be direct. If it was a company, it would be director's fees or whatever. So it's in the production of that income, and I think that deduction is justified or deductible. But your question relates, would his salary be taxable in SA or not? And I guess this is probably a question, is this of a South African source? Because it would only be under those circumstances that it would be taxable in South Africa. And I'm inclined to the view that if he's exercising his employment in another country for the CC, and those double tax provisions that I mentioned in relation to question 4 still was applicable, then you'd probably find the DTA would come to your assistance, and I'm going to deliberately use the word and give it the right sort of emphasis, may not be taxable in South Africa. Okay, there's clarification. The earlier question, thank you, there was a beneficiary, and I wasn't sure, was this a beneficiary of a trust or an estate, a deceased estate? And the person has come back to clarify, and thank you for doing so. The clarification is that it's from an estate, so that this is obviously an heir that we're talking about. Somebody has benefited from a deceased estate as an heir and is not tax resident. So I would need to just quickly go back and just check. You were the first. So let me rephrase the question now that we have these additional facts. How can an heir have his funds remitted abroad if one has not financially emigrated? So again, my answer remains the same. He hasn't financially emigrated. I wouldn't suggest that he rushes to do so. That would, in my view, be totally unnecessary. So how does he remit it? He uses his allowances. He's presumably no longer tax resident, but he's resident for exchange control. So he could use the 1 million or the 10 million, depending on how much is coming to him from the estate. Okay, we're going on, getting some good questions, and but we're nearing the end if anyone is watching the clock. Elderly client, resident in the UK since '88, wants to take out tiny proceeds of an RA in South Africa. Now, see, yes, you say he's elderly, tiny proceeds of an RA. I should have mentioned earlier that there are certain RAs, if either 75,000 or 50,000, if they are tiny, you haven't said how much tiny is, those can be cashed in. But yeah, you say he's elderly, so he's obviously over the age of 55. He's got a bank account in South Africa, we're told, which is his only other asset, and receives income of 24,000 per annum. Tax returns have been submitted for 2018, 2019, and 2020, needed a tax clearance certificate in terms of the MP336 for the authorized dealer to process. Yes, they're telling us, and that's correct. That's what they confirmed to us as recently as this morning, that you've got other assets, you've got a bank account, and therefore they would want the tax clearance. But it says the MP336 was rejected by Saab as he declared the death values instead of the much lower investment values of the retirement annuity fund. This was all done in December 2020. Now, how will this affect the February 2028 cutoff date? I would imagine Saab have a copy on this tiny case from December. Yes, indeed. So I don't think you have anything to worry about. I think you made the deadline. Yes, perhaps through an error or whatever, you just recorded the incorrect values. You put death values, they wanted investment values. I think you're in good time. Just deal with your authorized dealer. And my understanding is that the Reserve Bank will treat this as an immigration done in time. And if you have hassles, come back to us and I'll put Mike onto them with a huge panga and a machete that he has in his arsenal. Right, yes, the 10.1 is corrected, 10.10, no problem. I thought as much, mainly because I don't remember what 10.1 is and would have to reach for my act. And then there's somebody who says, thank you so much for your answers to my anonymous attendee questions. It's always good to have validation. Well, my response to that is you're most welcome and see you again next time. Some clarification on my question above, the RAF value was 45,000. The client is 85 years old. is that elderly? Stan? No intention of returning to South Africa. Why not? Anyway, yes, that's under 45 is under both the 75 or the 50, and my understanding is that that full amount can be withdrawn on the basis that it's really of nuisance value. So then we have another question relating to the very first one, and our friend here is really getting his money with, and you're absolutely welcome. That's what we're here for. We're back to the estate with the heir, and he left South Africa many years ago and now has no bank account in South Africa. He cannot use his allowances method to remit abroad. How can he remit? Very good question. Very good question. So the problem is that he hasn't emigrated. Now, this might be one of those situations where you could, there's no bank account, there's no insurance policy. You could quickly do an MP336 and go to the nearest foreign exchange or bureau de change of the bank, perhaps where your client, he doesn't have a bank account anymore, but presumably if he had one. We do know of certain banks, and we have arrangements where they'll open an account. But I would think that if you were to very hastily financially emigrate him, then the executors, on the basis that he's now a non-resident immigrant, there is a will, presumably, there's an LOD account that's been approved by the master, and the executors are permitted to remit the inheritance directly into his bank account in the country where he lives. Okay, that's the answer there. Yeah, so here's a question that relating to the previous question about our very young 85-year-old who put the wrong value, and it said it was the SARB that rejected the letter of explanation by the 85-year-old on the error of the RAF policy values. Really? Yeah. You know what? Let's take this offline. We will rattle the SARB's cages, and yeah, they're being unreasonable, and we'll help you with it. It's an absolute pleasure. Just contact us. I can't see. So as I said, you're in before the deadline. If they've rejected it, then maybe just resubmit it. You know, they would accept that. And I think this is indeed the final question. And it relates to a previous question. Read my previous question of the client taking up employment in Saudi Arabia, for who's leaving on April the 2021 for 5 years. For the February 22 tax year, will he be taxed in South Africa at all or non-tax resident? So, good question. For the February 22 tax year, he that's where if you do his tax return in the wizard, you're going to tick that he was non-resident. So what will happen is that his salary, presumably he's working for a South African employer, his tax return will already be pre-populated with the salary information up to the time he left. So let's say if he goes at the end of April, you don't give dates, but it's not important, the principle's the same. He works in South Africa for the months of March and April, and on the 30th of April, for instance, he leaves to take up his position in Saudi Arabia. The 2021, he would only be taxed as a resident on his 2 months' salary, that of March and April. And so your question for the February 22 tax year, will he be taxed in South Africa at all or regarded as a non-tax resident? So that's the year where you've got to apportion it because he ceased to be tax resident on, in this example, the 30th of April. So you would need to do an apportionment. It's not a situation where on the year you get regarded as the whole of the tax year. It goes, as Robert said, on days and so on. Right. I think we've exhausted all the questions, for which I thank you. They were really, I compliment those who took the trouble to put questions to us. Yeah, I think we're also probably close to time. By and large, we've held our audience. So I think, Stan, may I, if there are no further questions, thank you for the opportunity of participating, and hand back to you.
And thank you to your team for a very interesting talk. I'm sure people learned a lot. Actually, I learned from my father. He taught me about tax. He said, so every time I had an ice cream, he bit off 30%. And that was how I learned tax. About going forward, thank you very much for attending. As I said, your certificates will be on your way if you've paid. If you haven't paid, please pay, and we'll send your certificates. As I said earlier, Anthony, most illuminating. I'm not that I'm running away with my money. I haven't got any money to take, so it doesn't apply to me. But for those of you, I'm sure you learned a lot. It's actually riveting stuff. I didn't know that all of this existed. But clearly the taxman has ways and means. He wants to try and get as much money into the coffers as possible, and distribute it accordingly. But thank you again. Our next seminar is Jackie Aronsa. It's on the 2nd of March. We'll talk about tax again. And thank you again for everything. And as I said, Anthony, your team supported you ably, and very interesting topic. Danny, you want to say anything?
Thanks to everyone for attending.
Anthony, you were mentioning we're still discussing and planning a date, but your next topic.
Yes, that's in. I'll just mention it briefly. There's a slide on it. I didn't put it up. It was the last slide, other than the one with our names, address. It's on this concept of loop structure. So anyone who has anything to do with exchange control will know what a loop structure is. It's basically, for those who don't know, it's where you set up a structure, or a South African resident lurks in the shadows of, let's say, a foreign trust, and that trust or that entity invests back in South Africa, or not only in South Africa, but in the CMA. So it could be in Swaziland or one of the CMA regions. And for a long time, there's a history to it. So at one stage it was fine. Some of my colleagues went about and did very well in creating these loop structures. Then they were outlawed by the Reserve Bank. And there was a reason, because a loop structure allowed you to get money out from South Africa and put you at an advantage compared to other residents who had to just be content with the 10 million or the 1 million. But as I said from time to time throughout the presentation, exchange control has been liberalized, relaxed. I'm sure that will continue, and let's see whether Minister Mboweni says anything next week when he addresses us. And so loop structures, they present some interesting opportunities. The Reserve Bank issued its very first circular of 2021 on the very topic, and the presenters, in addition to Mike, he'll be joined by one of our other colleagues who was unfortunately involved with clients this afternoon and couldn't sit in, who's also an expert on loop structures, and that's our forthcoming attraction. So stay tuned.
Well done, and thanks.
Thanks very much. If there's anything else, please address your email to Danny, and he'll pass it on. Any questions that you may have off air, maybe you want to talk about things privately, engage with Anthony and his team. And thank you again. We'll see you in the next seminars. Watch this space. Good night.
Good night.
Yes, thank you.